organizers of the conference and to the organizer of the panel for the invitation. I would like to introduce the topic of my research, which is child's right to identity in the context of adoption. To start with identity, the concept of identity has multiple interpretations linked to psychology, anthropology, or philosophy, and it is linked to perception of the person, one's uniqueness and differentiability. Relevant notions are also national, ethnic, and cultural identity. And furthermore, the concept of identity is closely related to the human dignity, which is the foundation for the protection of human rights. Introducing the children's rights context, one should remember that the formation of the child's self-concept or identity, and their sense of who they are and what their relation to other people is one of the most important aspects of a child's emotional development. And what the right to identity is. It can be defined as the one protecting an individual's significant and knowable personal attributes and social relationships. The protection of the right to identity is an aspect relevant for international human rights law. The path to its protection was paved by instrument of general international human rights law, starting with the Universal Declaration of Human Rights. The right to identity is linked to many other rights, right to a name, recognition as a person before the law, right to a nationality, and the protection of private and family life, and protection of culture. However, right to identity does not precisely correspond to any of these rights. We should note the role of the Convention on the Rights of the Child. Its framework in the matter of child's identity was designed to answer violations such as forceful separation of children from parents, mostly during wars and conflicts. One may claim that the right to identity is essential also for implementation of basic values of the Convention on the Rights of the Child, prohibition of discrimination, the role of the best interest of the child, child's right to life and development, and the right to be heard. Importantly, nowadays, one of the contexts in which the right to identity appears very often is promoting and advocating for the registration of children's birth, what gives them access to all the other rights. Article 7 and 8 of the Convention on the Rights of the Child are crucial. Their scope of application is not obvious. Special attention should be paid to the requirements of the Article 8 on birth registration, protection of name and nationality, and the right to know and be cared by parents as far as possible. And Article 8 is the first ever human rights law provision specifically recognizing the right to the preservation of a child's identity and assistance and protection in their re-establishment. Arriving to the topic of adoption, adoption can be defined as the act of legally taking a child to be taken care as your own. In the past decades, it was seen mostly as a means to provide a child to childless couple. However, nowadays the need for a child-centered approach, child-centered nature of adoption, and a children's rights-based approach to the institution of adoption is emphasized. Convention on the Rights of the Child may serve again as a basic standard setter on children's rights in adoption, with a special emphasis on Article 20 on alternative care. Adoption is one of the means. And Article 21. This provision constitutes an exception to the general principle of the Convention, according to which the child should remain in the care of their biological parents. A child's identity because of that the child is not taken care of by their parents. Therefore, a child's identity is somehow disrupted as a consequence of alternative care and adoption. There may be a tension between a child's identity and their integration into a new family, between the truth about biological parents and or about adoption and protection of the child, their safety, peace, and peaceful development. Also, the interest of biological parents or sometimes adoptive parents may conflict the largely understood child's right to identity. These are essential legal issues and issues at the level of individual family, of course taking into account age and development of the concrete child. Particularly challenging is the situation of international adoption. Inter-country adoption is explicitly framed by Article 21 of the Convention on the Rights of the Child, but it involves cultural, ethnic, religious considerations. All relevant factors should be considered to protect the best interest of the child. Before deciding on an appropriate measure of alternative care, in particular adoption being the very far-reaching mean. And the choice, before deciding on the choice of adoptive parents, the issue of the continuity in upbringing is of great importance. It can be defined as the protection of what has been good in child's rearing so far. There are also safeguards in place to protect the child's right to a name and nationality in adoption situation. And particular attention should be given to the child's right to know their origins, amounting to know one's biological family and one's conditions of birth. Consequently, it protects individual interest to identify where they comes from, so the core of the identity. To show the dilemmas addressed mostly on the national level, I would like to briefly present some examples from the case law of the European Court of Human Rights. Firstly, precisely on the aspect of the rights of the child to access information on their biological origins as a part of development of their identity, the cases of adoption resulting from anonymous birth known to some legal systems, they are significant. The European Court looked into this scenario in the cases Odier versus France or Godelli versus Italy. The court acknowledged that the right to one's origins is a matter of private life. However, it is not an absolute right. There needs to be a balance between the right of the child to know where they come from and the right of the parent of origins to remain anonymous sometimes. Within the state's margin of appreciation, this delicate topic pertaining to individuals' relations must be handled by an appropriate domestic authority. However, the state parties must introduce some forms of, some elements of balance between the rights of the child to know their origin with other relevant consideration. Also, the anonymity of the parent can't be absolute. Also, in recent months, the European Court has addressed the issue of identity directly in relation to adoption. This was the case Mitrewska versus North Macedonia. Mrs. Mitrewska was a fully adopted grown-up child who sought information about her origins due to health concerns. However, the request was denied. According to a Macedonian Family Act, the information about adoption, about biological parents, was classified as official secret, and it forbids disclosure in any case. However, the European Court ruled again seeking for some forms of balance. The European Court ruled that North Macedonia violated its obligations under the protection of private and family life. The domestic authorities failed to balance competing interests and did not ascertain that in this particular case the applicant's biological or adoptive parents wished this adoption to remain secret. Therefore, a European Court found several issues with the Macedonian authorities' actions. This judgment emphasized again that knowing one's origins is a part of private life, and stressed the necessity for legislative changes in Macedonia and probably in some other European countries to prevent similar violations in the future. Another example as regards to child's identity and the right of the child to have their original cultural identity respected was the Norwegian case Abdi Ibrahim. This is a very illustrative case on the issue of the continuity of upbringing. This was the case of the child of the Somalian national adopted by the Christian family. Of course, we may imagine the different situation and adoption of Christian child or child of Christian parents by a Muslim adoptive family. And the European Court acknowledged the significance of the child's preserving their original identity, including ethnic, cultural, religious factors, also linguistic one. Nonetheless, this is the obligation of mean and not the one of the result, because of the feasibility of the different scenarios. These examples show a complexity of dilemmas which may be faced by national authorities, and show the need for balancing competing interests, which is a difficult task, but seem to be more just and more feasible than giving an absolute priority to a certain right, like even the child's right to identity. Thank you very much for your attention.